and everybody that has logged in. My name is Honorable Pinky Mncube. I'm a member of this committee. Thank you.
Thank you very much, Honorable Mncube. Is there any Honorable Schneeman?
Good evening, Chairperson, and good evening to all the other honourable members, and also a very good evening to all the guests and those who are watching on various social media platforms. My name is Greg Schneeman, and I'm also a member of this committee. Thanks very much.
Thank you very much, Honorable Schneeman. Tim, you'll also help me. Member Tong, are you back? Are you here? Member Malisela Ledwaba? Do we have anyone from the NCOP team? Please confirm so that they introduce themselves. Is our permanent delegation here?
Yes, Chair, we do have Member Mutsamai.
Oh, Member Mutsamai, our Member of Parliament, please introduce yourself to the public. Please switch on your camera.
Yes.
Switch on the mic, Tate Mutsamai.
Mic is on. I'm the Honorable Kenny Mutsamai. I'm member of National Council of Provinces in Gauteng, representing Gauteng in Cape Town.
Thank you very much, Tate Mutsamai Re a leboga. Is there any honorable member from the Gauteng Legislature that I'm leaving out? Who's here? I'm trying to follow the.
You haven't called any of the other members. I'll forgive you for that. So
sorry, my brother. My apologies.
I call them one by one.
The list is so long. Honorable Solim Simang, can you please introduce yourself to the public of Gauteng?
Thank you very much, Chairperson. My name is Solim Simang. I'm also a member of the portfolio. And welcome to all the guests and to the people that are watching us from different platforms. Thank you.
Thank you very much, Member Msimang. I know Member Amanda Dilange, she's not able to join us this evening. I knew that the Bishop, Member Dalton Adams, is also going to be joining us from Namibia or Zambia. I'm not sure, I forgot the country that he's joining us from. I think we will allow him to introduce himself as soon as he's logged on. Team, is there any member that I'm missing?
Sorry, Chair.
There's Member Dos Santos.
Oh, Member Dos Santos, please introduce yourself to the people of Gauteng. Show your face.
Good evening, Madam Chair. Thank you very much. Just want to say thank you for the initiative for this roundtable, number one. Number two, just want to say good evening to all the viewers and listeners that are participating in this roundtable. My name is Sergio Issa Dos Santos, and I'm the alternate member of this committee. Thank you.
Thank you very much, Mtate Dos Santos. Is Member Sirota here? Member Tong, are you back? Are you here?
Yes, Chair, I'm sorry about that. I'm struggling with network. My name is Member Tong from this committee.
Thank you very much. Okay, noted, Member. Thank you. Do we have, who am I forgetting? Mtate Sirota? Isn't that this Rota here? Okay, he'll introduce himself. Sirota, the participants are so many, so I would not be able to see everyone who's here. I have noted that the chairperson of the Public Service Commission is here, Tate Silwane. Tate Mike Silwane, are you able to greet the people of Gauteng?
Thank you very much, Honorable Chair. Just a correction, I'm not the chairperson, I'm just the commissioner of the Public Service Commission.
Receive.
Good
Receive
evening,
the
everybody, and we are here to participate or listen to the deliberations on the amendment bill. Thank you.
Thank you very much, Dr. Sloan. Maybe it might happen that you are the chair. Just receive the blessings from us in Gauteng. It's our wish. I see we also have amongst us members of Parliament, Ntate Boisimaneli. I'm going to be missing a lot of you, so if you are here and you are an honorable member that serves both in Gauteng or in the National Parliament, just indicate on the chat so that we acknowledge you accordingly. It's now 4 minutes to 6. I was trying to buy time for us to be able to start on time. And hopefully the team, Fano, is monitoring on our behalf the social media platforms that we are broadcasting this roundtable on local government municipal system amendment bill. And we will now start. If you are here and you are an honorable member, you'll just indicate so that we acknowledge you. I saw Honorable Member Boisimaneli, who is from Parliament, if it's you. I know our colleagues also might be here from the Gauteng Provincial Legislature and the Executive, and we might not have seen you. Please pardon us, and you are all welcomed. I've also seen a number of councillors from different municipalities in Gauteng are here. We all acknowledge you, and you are all welcomed. I see also, I'm told we have the PSC Commissioner, Lulu Sizani from Eastern Cape. You are also welcomed in Gauteng. I've seen all of you. I see my professors, Professor Natasha Holthausen from University of Pretoria. You are welcomed. I see activists within the space of public policy. David Maimela, you are welcomed. Our panelists, Dr. Onkgopotso Madumo, you are welcomed. And Professor Pillay, you are welcomed. I think people of Gauteng will see you as and when you present. And I'm going to request that as and when we speak, we switch on our cameras so that everybody is able to see us. It's now 2 minutes to 6. I hope the legislature will now allow me to start with the program. I see Dr. Sam Koma, he's one of the panelists. I also forgot to acknowledge the Provincial Department of CoGTA, led by Ntate Bongani Cileshe in Gauteng. Ntate Cileshe, ngicela usi introduce ku abantu base Gauteng bakubone nje bakwazi ukuthi ubani. He's been with the department for a year now. Cileshe?
Yes, sir.
Please introduce yourself.
Yes, I'm Bongani Cileshe, the head of CoGTA. I'm with the other CoGTA colleagues. There are many of them. I can't be able to introduce them now. Thank you, Chair.
Thank you very much. I know the National Department of CoGTA also indicated that they will join us. I just don't have the names clearly as to who is the representatives. Are they here?
Thank you, Honorable Chairperson. My name is Tebogo Motlasuping. I'm from National CoGTA, and I'm with the team to give support to the portfolio committee.
Thank you very much, Ntate Motlasuping. Re itumetse thata go ba le wena gompieno. I know there are different organizations represented here. Some local government unions are also invited. Is SAMU in the house? Is Imatu here? Do we have anyone from Salga?
Chairperson?
Yes.
SAMU is here.
It doesn't want the nation to see it.
But we are available. You can see. It's just that we might not be in a very light area, but
we can see.
Available.
Thank you very much. I think people of Gauteng will want to see who's the leadership of the unions that are responsible for service delivery in our municipalities. And thank you very much for showing your face. I know amongst the organizations invited, some of them are going to be making presentations. So we would acknowledge you as and when you make your presentations. And I'm going to request colleagues and fellow activists within the space of local government to also, as and when you speak, introduce yourself and switch on your camera for our portfolio of evidence as a portfolio committee in Gauteng, as and when we report back to the legislature. I'm no longer going to be acknowledging anyone. I acknowledge all of you. I've seen a lot of former municipal managers, current and CFOs. I think this is and young activists, young people who are still scholars within the space of local government. So you are all welcomed. And I think one of the reasons that brought us here today is the fact that the Local Government Municipal Systems Act was constitutionally challenged in 2016 at the High Court in Pretoria. And this was a matter between SAMU versus the then Minister of CoGTA. The Local Government Municipal Systems Act was introduced to Parliament as part of the local government turnaround strategy to strengthen institutional and administrative capacity of municipalities. And unfortunately, the bill was tagged as a Section 75 bill, which meant that it is an ordinary bill not affecting provinces. So the court found that the Amendment Act, I'm sorry about that. The court found that the act should have been tagged as a Section 76 bill because of its importance and the role that the provinces play on municipalities, and therefore it was then declared invalid, and a process was set out to ensure that it is referred to as a Section 76 bill, and the matter was then further taken to the Constitutional Court. And I think there's a reason why we are here today to discuss the Local Government Municipal Systems Amendment Bill. And the bill seeks to insert and amend certain definitions to make further provision for the appointment of municipal managers and managers directly accountable to municipal managers. It also seeks to determine timeframes within which performance agreements of municipal managers and managers directly accountable to municipal managers must be concluded. It further also wants to make provision for the evaluation of performance of municipal managers and managers directly accountable to municipal managers, to also stop municipal managers and managers directly accountable to municipal managers from holding political office in political parties, as well as to regulate the employment of municipal employees who have been dismissed, and to provide for the minister to make regulations relating to the duties, remuneration, benefits, and other terms and conditions of employment of municipal managers and managers directly accountable to municipal managers. So prior to the enactment of the Municipal Systems Amendment Act of 2011, municipal managers were appointed in terms of Section 82 of the Local Government Municipal Structures Act of 1998, while managers directly accountable to these municipal managers were appointed in terms of Section 56 of the Municipal Systems Act of 2000. So the National Department of Corporate Governance and Traditional Affairs highlighted that such appointments had the following implications. Amongst them is human resource disparities on human resource practices, appointment of persons without the requisite professional and technical skills. I think all of us are aware of what has been transpiring throughout some of the municipalities in the country. The under expenditure on capital budget, something that all of us are worried about. And this has an impact on ensuring that there is community development in our different municipalities. Ineffective revenue collection strategies resulting in high municipal debt. I think many of our municipalities also here in Gauteng are struggling with revenue collections, and I think from time to time, year in, year out, the Auditor General will highlight that as part of the challenges that our municipalities are still struggling with. The collapse of rule of law resulting in fraud and corruption. I would not want to deliberate more on this. I think this is as the people of South Africa generally, not only in Gauteng, but I think these are the challenges that most of our municipalities are faced with, if not all. The prolonged labor dispute from some municipalities with huge sums of money intended for service delivery spent on defending labor disputes. I think those of you who have been municipal managers and mayors are aware, and those of you who are in the unions, you would know the wage bill and the bill that we have on labor disputes only. And this has an impact on us ensuring that we uplift the socio-economic conditions of the people that we seek to serve as government, and especially as local government. So the Constitution of South Africa envisaged a robust local government system which can provide democratic and accountable government for our communities. And amongst the things that democratic local government in South Africa seeks to achieve is to ensure the provision of quality services to our communities in a sustainable manner, promote socio-economic development, promote safe and sustainable livelihoods, and encourage the involvement of communities and community organizations in the matters of local government. I think we are all aware most municipalities are now conducting public participations on integrated development plans. So as a portfolio committee, we are hosting this roundtable discussion in order to provide a platform where you as stakeholders, experts, and members of the public can make inputs on the bill as part of the consultative process outlined in our constitution as a republic. So as Gauteng Legislature, we decided that we do it in this fashion, and we are going to be conducting different public hearings with different stakeholders. And today is the beginning of that process of the bill. So you are all welcomed, and I think I've tried to clarify the reason why we are converging here today. We have invited a team and all of you to make inputs on this, but people who will be guiding us as our panelists will lead us in the discussions. And I'm now going to allow the Department of CoGTA in Gauteng to make its presentations on the matter. I've also been made aware that the National Department of CoGTA also has a presentation. So I'm going to, I think protocol-wise, the province will start and the National Department will come after. So Ndate Hamilton Morabe will be representing the Department of CoGTA in Gauteng, and he will be followed by the National Department. So we'll first take these presentations and we'll have our contributions from our panelists and all of you who have been invited to participate in this session. It's difficult to be vibrant and lively, but I will try my best to ensure that you don't sleep through the presentations. And I believe that my presenters are also very vibrant individuals that will make sure that you are able to concentrate throughout the proceedings. And I would like the team that is monitoring the social media platforms to also indicate to us as and when there are questions. So how we will run this platform is that we'll have the two departments, which is the provincial and the national department, presenting, and then we'll have contributions from our different panelists, and then allow all of you who have prepared. I know PolitySpace have prepared something for us. I know some of the students that contacted us as the legislature that has prepared 5 minutes presentation on the bill. You'll also be getting an opportunity. So everybody is going to participate and make their contributions. So feel free to raise hands, but we will do those discussions immediately after our identified panelists. So I'm handing over to you, Hamilton.
No, thank you, Chair. I hope I'm visible.
Yes, I can see you.
Yeah, I hope the sound is also, it sounds like from my so. Let me first, I wanted just to switch the camera on so people can see who's speaking to them, and then we'll switch to the presentation. But first, let me acknowledge and thank you, Chair, for giving us the opportunity to present to our communities and members, and also thank members and also greet and thank members of the Portfolio Committee, all honourable members and our members at our national parliament as well, from our particular house of participation, and also acknowledge the HOD of CoGTA in Gauteng and other members of CoGTA leadership and leadership of CoGTA at national as well. And other esteemed members of this discussion, and also greet the people of Gauteng. The presentation, Chair, I think you have gone to quite a very extensive process to speak to the reason why we are here, which is to speak about the amendment of the Municipal Systems Act. But I think you have gone quite in detail and quite in detail around the background about where we come from. So we might not spend a lot of time there. But also that the National CoGTA is here. They are also going to make a presentation. I think they're also going to be covering a number of issues that are covered by the bill itself. The nature of the presentation is to leave it, not necessarily to go into the particular bill, but I think with regards to the background, the chair has particularly covered quite a lot of ground around where we come from. That the Systems Amendment Act is not the first time that it's been amended. It would have been amended before in 2011. It actually would have also been operationalized through the regulations after its amendment, which were promulgated in 2014. But however, there would have been challenges around it from some. I think these areas would have been covered to a great extent by the chair around the mainly two elements around the process that has been followed, which is the chair would have spoken to around tagging. So it should have been tagged as a section. The wrong section of tagging was used, which at the time tagging was section 75 of the Constitution was used instead of section 76, which speaks to issues around bills that affect provinces and how provinces themselves should be consulted and participate in the development of such bills, which culminate into acts. Which, of course, yes, that challenge would have been mainly successful, and we would have been given an opportunity as a sector, particularly Parliament, but of course led by ourselves at National CoGTA, to look at correcting that defect around the tagging of the bill and around the applicable consultation processes. So that being the case, overall, what would have brought us to this point is that at the end of the fifth administration, there was a drive from National to look at addressing those areas around consultation on the bill through the correct processes. But I think there would have been issues of timing, and we couldn't make the period that we couldn't be within that period before the end of the fifth administration. So the fifth administration came to an end before the finalization of the process. That is why the bill is now the bill is referred to as a 2019 bill, because it would have been began in 2019 at the start of the sixth administration. So overall, the purpose of the bill covers in the main the issues of senior managers and the managers that report to municipal managers in municipalities. But many of the areas that are in the bill are not new. Many of the areas actually would have been covered from 2011 and what we would have operationalized through the regulations themselves. And we also had found that there would have been quite a number of very good things that would have assisted us in terms of establishing local government to be much more institutionally sound and to assist it to be stable and to take it to some extent so that you bring in people that are quite more skilled, qualified, and are competent in the work that they do. So looking at what we would have done over the period and what would have been operationalized around the issues about appointment of senior managers, many of those are actually coming back into this bill, but it's just that these are done through a correct process now. But many of the areas around the appointment of senior managers and those MMs around, as would have been referred to earlier, issues about the competency criteria and procedures on the appointments, especially around the consequences around what happens if there's contravention around the procedures and processes on appointments of senior managers and the particular requirements. It covers also employment contracts and performance agreements of senior managers. It also limits the holding of a political office. It limits the rights of holding a political office of Section 54 or Section 56 managers. They are referred to as Section 54 and 56 managers because in the Act, that's the section at which they would be referred to, those municipal senior managers and municipal managers. It also speaks and regulates issues and enacts issues around employment of dismissed municipal employees, with and it also has greater emphasis around employing people that would have been found guilty around financial misconduct in municipalities to that effect. It speaks about duties, remuneration, and benefits, and other conditions of employment of municipal senior managers in municipalities. So in the main, its main thrust and focus around municipal senior managers and MMs in municipalities. However, there are also other areas that it covers, and those include extending to ensuring that the employment of staff in municipalities are only against posts that are provided for, and the consequences of contravening that. This is also part of the very important elements to ensure that municipalities going forward, issues around how the staff complements on municipalities get bloated from every term of office for whatever good or bad reasons. This at least start to be kept, because this speaks mainly very directly to issues about financial viability of municipalities, where you find that municipalities in the main, if their staff costs in some municipalities are starting to go even beyond 75%. So it becomes a problem around the financial sustainability of municipalities. And it also brings other elements around consultation by the minister, consultation by local government with the minister around the issues about collective agreements. These are actually main drivers around the issues about collective agreements becomes main drivers that affect one, the viability of municipalities, and secondly, the issues about the salaries of municipal senior managers, which becomes complicated in the long run, where you find that it becomes a problem to fill the salaries of senior managers at certain salary levels, because you would find that through the collective agreements, the agreements that would have agreed to make managers or other employees that report to Section 54 and 56 managers, even their salaries to be equal or even higher than those. So it then becomes a problem around finding that you are able to attract and pay those senior managers at a good enough rate, but also underlying factor also is about financial viability of municipalities. The other key factor that we thought we should also highlight is around the fact that in the Act itself, it also highlights that councillors may not vote for a resolution that is in conflict with local government legislation. This is also quite an important element that going forward, every care and consideration must be given on what we resolve to do in municipalities, and what are the impacts of those, and whether we are compliant. So therefore, this also to an effect is important, because it will assist us to get our municipalities to look at those particular areas around, to an extent, you may say self-regulation, to every time look at what are the impacts of the decisions that are being made and the legality of those decisions going forward. So in essence, and in a brief space, Chair, that's the main thrust that we thought we would highlight in what the Act is about, without necessarily going to the specific sections, because we take it that members would have gone through and other participants would have gone through on what are the key areas around those, but particularly on those ambits. The position of CoGTA on how we see the bill itself from the Department of Gauteng CoGTA perspective. We in the main support the bill, and especially from the main perspectives that in our view is going to assist us in professionalizing local government. It will also assist in our goals around building capable leadership in municipalities, capable administration in municipalities, and towards building the state capacity in implementing programs of the state. It also would assist in containment of staff driving us towards municipal financial viability from an employee cost perspective, and also actually also from a governance kind of perspective. It's going to assist supporting this bill, of course, is going to be the regulations on appointment of senior managers, which would also emphasize the issues about attracting the qualified, competent, skilled, and expertise in municipalities, and to enable us to attract those kind of skills in our senior managers in municipalities, but also other considerations around how we must be sourcing this kind of competencies nationally, so that we're able to when we advertise for posts, we go in national and attract competent people around the country, and not only to look at small spaces or local spaces, but competent people around the country who have the requisite skills countrywide, who can buy into the agenda around the expanding our services to our people in an effective and efficient way. Also that it brings the oversight role of the MEC and the Minister over appointment of senior managers. And also that it provides for waiver provision with around municipalities to attract skills. However, while we support those particular areas, we still also support the issue around the issue about limitation of political rights, which is a thorny issue at some point, but it's been demonstrated that the blurring of lines between politics and administration have become difficult over the period of time. But even given the lessons of what we have learned from the 2011, the limitation of these political rights has to some extent contributed to stability around removing those blurring of lines and those grey lines around politics and administration, especially when you find that what is the process of.
Sorry about that. Colleagues, please switch off your mics. Thank you very much. Continue, Hamilton.
Thank you, Chair. Yes, I think the point I was just trying to make emphasis on is around the issue around the fact that limiting the political rights also actually in actual fact contributes to issues of stability around removing those blurring lines around find that in some instances a municipal manager may hold a particular political office where you find that the mayor actually reports to an MM in a political space. So that we found that limiting those rights of municipal managers kind of removes those blurring of lines, and it actually ensures good governance. The political rights are not so much governed to political participation, but it's about holding the certain political leadership positions in political organizations. So I think those are very well defined, because it's not so much about limiting political participation, but about limiting political leadership in political organizations. And I think those are also quite well defined from in some of the organizations they are defined as top 6 positions. In some they are defined as top 5 positions, which range from chair to secretary general, those kind of positions. So those that are in a leadership from a branch level of your typical political organization to your regional, provincial, and national level, but not so much about political participation. The other areas that we think they are also defining very well is around the performance agreements. because the basis for performance, I think we think it's about performance agreements. That's going to assist because when people perform without those that are not stipulated very well, part of how municipalities perform is around how their leadership performs. So if you define those agreements and ensure they are always in place, it will take us to somewhat address challenges around our performance of municipalities to quite some extent. The regulation of dismissed staff, we think that this is also quite important because it stops the circulation of people that hop from one municipality to the other, having done one form of misconduct or misdemeanor in one form or the other, but also the emphasis on financial misconduct, which is also one element that is also welcome. The bill itself also makes provision for the minister to make other determination around employment of dismissed staff and define them better going forward, which will also likely to be covered in the regulations coming. The issues about employment of staff to approved posts, we think that is also sound, and it, like we had emphasized earlier, it will also contribute to good governance and sound financial management and sound financial viability. Further issues that we think would need to be considered after all that is given is we think that the bill in its nature now and going forward still may want to look at defining better areas around acting period in exceptional circumstances, because those, while we accept that it's important to always fill positions within a prescribed period to ensure that we have viable and our municipalities are institutionally at sound level. There are exceptional circumstances such as litigation periods, which becomes lengthy, and somehow you find that those, if we don't provide for, they always would define somewhat non-compliance. Those issues around, we think that we should look at defining some of those areas around the lengthy litigation periods or any other exceptional circumstances. Another issue is having learned from how we had done the appointment of municipal managers through the MEC when he was looking at the issues that would be complied with on the appointments themselves. Our thinking is that the 14-day periods that would have been provided in many instances were not necessarily sufficient, especially that some of our municipalities may play technicalities because they may provide the MEC with the reports that are not complete, and later on then say the MEC has not fully considered the appointment while not complete information was not provided. And that kind of gap, we think that if a 14-day period or a 30-day period was to be given, it should provide that is around where all information is given, and also that there must be penalties for not providing full information, also around the issues around the municipalities not and to close that gap around the technical issues that are played around the 14-day period for MEC to provide his opinion on appointment, where he is required to do that sometime with limited information. The other issue that we thought is also a challenge is around concurrence, because in some instance the only provision here is around that if there's no compliance, then this matter must be taken to court. Shouldn't there be another different consideration around where MEC actually does provide concurrence? Because at that point, where there are challenges around incorrect appointments, they can be stopped there without necessarily finding that you can actually leave the matter to go to court, and which may take itself quite a period of time. And at that point, a person may be in a position by the time that gets concluded, it may be an end of a term. So which may be part of the problems. Another issue that we think it must be as a matter of emphasis is what becomes consequences for municipalities that either do not provide proper information or do not report, and also do not keep records on cases of staff that are dismissed. So that we think it's important, because this element about employment of dismissed staff or disciplinary procedures, and that it makes meaning when all municipalities participate and provide correct and relevant information, because if that is not done, you would find that at some instance when municipalities look at whether potential employees have been dismissed or not dismissed, if one municipality who's where they were has not necessarily provided record of those information, such person would have been deemed not to have issues, but in actual fact, you may find that that person has issues, it's just that those issues would not have been reported by such municipalities. As we run towards conclusion, Chair, the one key issue that we think is also important to look at as a matter of emphasis around remuneration of municipalities. While we take it that in terms of the current frameworks that we have, there are considerations to look at differentiated municipalities. There are many areas that we think constrains municipalities because they are defined to an extent where it is not a municipality is not able to provide a negotiated settlement given parameters of what should be given. So the demonstration is where you find that a person is only considered whether he's competent or whether he's a superior competence, and the payment is only around that. So while there's still consideration about qualifications and that, but at the end, all that it comes to what is the competency outcome. So we think that that also needs to be looked at much more closely, so that it allows, especially our municipalities in Gauteng, to negotiate the salary packages, especially that if they are able to negotiate those salary packages within a category that has been defined for them, which will make will also reduce the issues about non-compliance, but it also would allow us to be able to fill the positions of senior managers at greater speed, and allow us also to attract the best of skill available from the market per se. The last key areas that worries is, and we think it should also be provided attention to, is around the competency achievement of the basic competency outcome when senior managers are taken for competency, is that should we continue to provide for basic competency outcome, or should we start looking at those senior managers that are actually from competent and beyond? And those that are not competent, why do we want to still continue looking at them, while in actual fact, our framework on payment of senior managers do not necessarily provide for those kind of competency outcome. In brief, Chair, I think that will be the brief view, without necessarily going into much detail of the bill itself, but to highlight some of those areas. And I want to thank the Honorable Chair and members for giving us the opportunity to present. And I'm not sure how we would want to take questions, or whether we want to take the national presentation first. But yeah, that will be our presentation, Chair, and thank you very much.
Thank you very much, Tate Hamilton Morape. Remo Tlashuping, is it you who's making a presentation?
Yes, Honorable Chairperson.
Are you able to do it in 15 minutes? Because you confirmed late, eh?
I'm going to do it less, because I'm not going to repeat what my colleague has.
Okay, I'm giving you 7 minutes. Am I fair?
I'm not even going to be on the presentation, because the presentation, its content, it's the same as what our provincial counterpart has just presented to the honorable member. So I'm not going to repeat that.
Okay, give us a helicopter view then that you have 10 minutes. Thank you very much. Continue.
Okay. Firstly, I'm going to touch only on 3 issues that he did not touch on because he might not have been privy to the discussions that we had with the Portfolio Committee of CoGTA in Parliament and also the NCOP. And these issues are as follows. One is in relation to in the instance that municipalities submitted relevant documentation to the provincial department and to the MEC in particular, and subsequently to the minister. And both the MEC and the minister do not respond within a reasonable time to the appointment of senior managers as submitted by municipalities. Then the Portfolio Committee included a new clause that says in the event that the MEC and the minister do not respond within the speculated time in the regulations and in the Act, then such an appointment shall be deemed to be in compliance with the regulations and with the principal act, which is the Municipal Systems Act. So that is the new inclusion in relation to making sure that MECs and the minister respond within the speculated within the regulated timeframes in the Act for municipalities to finalize and conclude that such appointments. That's number one. Number two is in relation to holding of political office. Now, the prohibition in 2011 was only limited to municipal managers and managers directly accountable to municipal managers, the so-called Section 56 managers. But Parliament, through its Portfolio Committee, included another clause that says this prohibition of holding political office is extended to all municipal staff members, meaning it is no more the proposal as it stands now with that new inclusion is that all staff members of a municipality are prohibited from holding political office. And when this act becomes an act of Parliament after being ascended by the President, those who already hold political office, be they senior managers or staff members below senior managers, will be given a period of 12 months to comply, meaning they will be given 12 months upon the ascension of this bill into act. They will be given 12 months for them to comply with the prohibition clause that says all staff members of a municipality may not hold political office. And political office is defined as in the chairperson, deputy chairperson, secretary, deputy secretary and treasurer, and any other person holding a position of power in a political party, be it locally, regionally, or nationally. So those are the inclusions that were suggested at the Portfolio Committee, and they are included in the final bill that we also sent to Parliament. The last one is in relation to the employment contract of managers directly accountable to to municipal managers. Now, we will recall that in the 2011 amendment, there was a deletion of Section 57(7), but there was confusion in relation to the interpretation of the deletion in as far as it related to managers directly accountable to municipal managers' contracts. Now, this new insertion by the Portfolio Committee, which is also included in the final bill itself, is that the municipality will then have to look at its own circumstances when employing managers directly accountable to municipal managers. And will they then have a choice whether to employ those managers either on a permanent basis or on a fixed term basis. But this can only happen after the municipality has been consulted, the mayor, the executive committee, and supported or recommended by the municipal manager. So this new clause that has been included by Parliament is that there is a hybrid way of appointing managers accountable to municipal managers, the so-called Section 56 managers. Depending on the circumstances of a particular municipality, the municipality will then take a decision either to employ them on a permanent basis or on a fixed-term basis based on the circumstances of each municipality, and after council has been consulted, mayor has been consulted, the executive committee has been consulted with the recommendation of the municipal manager. Those were the three issues that I wanted to put in addition to what my colleague from the provincial department has presented. Thanks.
Thank you very much, Ntate Mutla-Shuping. I have noticed amongst the participants that have joined us, MMCs from City of Joburg. I've seen Comrade Loiso, Lugayeni Masuku. I've also seen the Executive Mayor of Sedibeng, Executive Mayor Lerato Maluka. I've also seen Professor Tito Carlo. I don't know which organization are you representing, because you represent many. I know you have a SAPAM, CAP, a Professional Business and Academics Forum, and you are also a professor of one university within Gauteng. I also have seen Dr. Reggie Lehwabe, who is a former employee of MISA, Municipal Infrastructure of South Africa. And amongst us also there's Makaziwe, who's also from MISA City Sustainability, responsible for Mohali City and Midval. I've seen also the Midval City Manager, not City Manager, CFO. I've also seen former City Manager of City of Tshwane, Opangwani. I've seen the former CFO, Andile Jakala, and you are all acknowledged. As and when we see some of you, will acknowledge you properly. I've seen the Mayor of Lesedi is also here, and some of you have identified yourselves as mayors and municipal managers, but I think we are satisfied with the attendance from municipalities themselves. Thank you very much. I'm going to now hand over to Dr. Sam Koma to make his contributions as one of our panelists. Dr. Koma is, I think, he's familiar to many of us within the space of local government. He's a local government expert. We always see him on TV, and many of us have been his students before. So we will now hand over to Dr. Koma.
Okay, thank you, Chair, and also thanks for the introduction. Good evening, ladies and gentlemen, honorable members, stakeholders at large, as well as my academic colleagues who are present here today. And also, I really appreciate the opportunity that I've been given to share my thoughts on some of the key considerations related to the Municipal Systems Amendment Bill. I'm going to confine myself to Section 54, which is the second slide, Jabulile. Section 54, which is already contained in the Principal Act, as well as the Municipal Systems Amendment Bill. So there are a number of court judgments already flowing from the Constitutional Court, recently the Supreme Court of Appeal, and the High Courts regarding the interpretation of Section 54A and also related matters. So part of the background is to say that Section 54A was introduced into the Principal Act, which is the Systems Act, by virtue of an amendment promulgated on 5 July 2011, hence the Samu Concord case. So prior to that, the Constitutional Court, the 2011 amendment introduced measures that professional qualifications relevant, you're moving fast, Jabulile. The second slide. Oh, yes. If we look at the recent judgment of the Constitutional Court that interpreted Section 54A and Section 54A3. You have the case of Nojawa versus Makana Municipality. In brief, Mr. Nojawa's appointment as a municipal manager was not confirmed by the MEC for local government on the basis of lacking 5 years senior management experience as per the advert and also as per the ministerial regulations of 2014. His appointment was rescinded by council following the MEC's instruction. Subsequent to that, he took the matter to the High Court and also the Constitutional Court, arguing that as a former full-time councillor and ESCOM member, he had 4 years senior managerial experience. So the court held that Mr. Nojawa's experience as a councillor did not amount to managerial experience and dismissed his application, despite the fact that he holds the BProc and the LLB degrees. But the Concord did argue that he does not have the required managerial experience as required in terms of the regulation and also the Act. The second slide, Jabulile. The second case flows from the Supreme Court of Appeal, the 2020 judgment, very famous case of Nkandla local municipality in KZN versus the MEC, and also the Mtonjaneni local municipality still versus the MEC. But the issue there was related to the MEC's legal review of asking the High Court first to invalidate the appointments of the two municipal managers, namely Mr. Jili, who was appointed by the Nkandla local municipality, and Mr. Sibia of Mtonjaneni local municipality. So the point of contention was the delay made by the MEC, as Bongani did allude to, the 14-day period in instituting legal review of these two appointments of municipal managers made in 2018. So the MEC took more than 2 years to bring a review application to set aside these appointments. So the two gentlemen lost the case in the High Court in KZN. They took up the matter through appeal to the Supreme Court of Appeal. So the latest judgment coming from the SCA is that the court declared the appointments of the two gentlemen invalid, but unlike the High Court, did not set the appointments aside. It held that allowing each to see out his contract will allow for continuity and minimize disruptions in the administration, since municipal elections must be held before 1 November 2021. The third case is coming from the High Court in the Eastern Cape. It's a case of Maonga versus the Walter Sisulu local municipality. So Maonga's contract as a municipal manager was renewed before its expiry, without the post being advertised nationally and without following a competitive process. So the court found that the decision to renew was unlawful and in contravention of Section 54A, subsection 4 of the Systems Act. Bongani already also discussed that. So the framers of the Municipal Systems Amendment Bill have now inserted a subsection in relation to Section 54(4)(c) that provides the employment contract for a municipal manager must stipulate the terms of the renewal of the employment contract, but only by agreement between the two parties. So it's not a foregone conclusion that your contract as a municipal manager will be renewed without having looked at the need to advertise the post nationally as part of attracting a pool of suitable candidates. The next slide. So the fourth case is also from the High Court in the Eastern Cape, involving Saka Sizwe local municipality versus Ms. Chefu. So the municipality sought to review and set aside its own decision to appoint Ms. Chefu as its Director of Integrated Planning and Economic Development as null and void and in contravention of Section 56 of the Systems Act. And in addition, asking the court to declare her salary package and remote allowance as irregular. The decision of the court was to confirm her appointment as director because the court said she meets the prescribed requirements of the post of a director. She has the 5-year middle level management experience plus the required qualifications. But then the salary at maximum salary package was set aside and was replaced with the salary at the minimum package in line with the regulation governing the upper limits of total remuneration packages of municipal managers and managers directly accountable to the MM. In conclusion, the law places a greater responsibility on municipal councils to appoint suitably qualified individuals into senior managerial positions aimed at ensuring that basic services are delivered to local communities in a sustainable manner. 2, the MEC for local government is given clear-cut timeframes to assume and fulfill oversight role over enforcing compliance with Section 54A of the Systems Act regarding senior appointments without delay. And very important in summation, this amendment bill serves as a significant step with a view to delink, not depoliticize, but to delink party political office and statutory senior municipal posts, that of the municipal manager, the managers directly accountable to the municipal manager, but very important, as Mr. Mutlashuping alluded to, the insertion of the prohibition of staff members also from holding political office. So it is aimed at doing away with the wearing of 2 hats in the execution of municipal administrative obligations, which has been the situation evidenced by the diagnostic report of CoGTA in 2011 that gave rise to the local government turnaround strategy. That is the end. Thank you.
Thank you very much, Dr. Koma. I'm told that there are live chats on our social media platforms, and some of the questions are directed to the National Department of CoGTA and Provincial Department. I'm going to request you, Ntate Mutlashuping, with your team, to also go to the sites and try to clarify some of the questions asked. Oh. Was I audible or was I muted? Okay. I was saying thank you very much, Ntate Koma, for your insightful presentation. We are in partnership with Mail and Guardian. We're also live on their website. We are live on YouTube. We are live on Facebook. And there are specific questions to some of the presentations made here. I'm going to request you, Ntate Mutlashuping and Hamilton and Tate Tileshe from Gauteng CoGTA to go to the sites and respond to the questions asked there. Some are very specific to the role of your departments. I'm also going to request executive mayors that are on this platform and municipal managers to also visit the social media sites and respond to questions specific to your municipalities. But otherwise, some of the questions, especially as they relate to the bill, the amendment bill itself, will have an opportunity to raise them on this platform. I've acknowledged many organizations that I hear. I've seen somebody identifying himself or herself as Nelson Mokoto, who is a SAMU president. I'm not sure if he is here. I know that we have founder of the Polity Space, Mr. David Maimela, also with us. We have earlier I identified Professor Natasha Holzhausen as a professor in the University of Pretoria. I've been corrected. She's from Chartered Institute of Audit, Governance, Oversight and Leadership. And we'll continue to acknowledge all of you as we move on. I've seen a lot of students, Khotomaja, you are also acknowledged, who have requested to participate as this is part of their research work. Yeah, so we'll continue acknowledging all of you as and when we see you. We are moving forward. Please note your questions and your input. Our next presenter is Dr. Onkgopoze Madumo from the University of Pretoria for 10 minutes.
Oh, thank you very much, Chairperson. Good evening to you, Chairperson, and good evening to all honorable members and distinguished guests, and to my fellow panelists, good evening to you. And thanks for the insightful presentations that you have made. Chairperson, it is indeed a privilege to present to make a presentation to the Portfolio Committee on CoGTA and Human Settlements on this specific Municipal Systems Amendment Bill. Can we please move to the next slide, Jabulile? So the main point of my presentation, I have limited it to covering only specific aspects, given the restricted time allocation that we have been given by the Portfolio Committee. So I will be focusing on just a brief explanation of the purpose of the Systems Act. I'm also going to cover the purpose of the Amendment Bill of 2019. Particularly, my interest is on the appointment of senior officials. This would be municipal managers and managers directly accountable to the municipal managers. And the other second aspect that I have focused on, or that I have zoomed into, is the employment contract and participation agreement of senior officials. Next slide, Jabulile. Now, in terms of the purpose of the Act, this principal act, which is the Municipal Systems Act, serves as an enabling tool for a creation of a systemic local government. Simply put, the Act provides an engine for the operation of local government. The Act also provides a description of the legal nature of a municipality. For 2000, I believe, the Municipal Systems Act, prior to the 2000 amendment, it used to refer to, or rather, it used to create a confusion between municipality and municipal councils. And as a result, the proper accountability was not, achieved, where the Act would, for example, say the municipality will have to appoint a municipal manager, for instance. And when it, got to matters of litigation, it was difficult to determine who the municipality is. So post, that amendment, the municipality has been provided clearly as a legal entity. The purpose of the Principal Act is to also enable the exercise of the municipal powers and functions. Can you please move to the next slide, Jabulile? Now, the bill addresses quite a number of issues. And when you look at the 2019 bill, as it has already been alluded to by the previous speakers, it addresses quite a number of issues. However, there are some of new issues that have came into the 2019 bill as opposed to the 2011 bill. My particular focus was on strengthening the processes of appointment of senior officials, on the introduction of consequence management of for appointments that are not compliant, as it has already been, discussed, the 14-day issue of the ministers not responding or the MEC not responding, the establishment of timeframes for conclusion of performance agreements for senior officials, and most importantly, the exclusion of staff members from holding political office, as it was discussed by the previous two speakers. Can you please move to the next slide? In terms of the appointment of senior officials, the bill aims at regulating the appointment of the municipal manager and Section 56 managers or managers directly accountable to the municipal manager. And when you look at, for example, Section 54A, paragraph 2, persons appointed as municipal manager must have skills, expertise, competencies, and qualifications. Now, this creates a little bit of vague, a vagueness insofar as this particular clause is concerned, because when it says skills, expertise, competencies, and qualifications, it does not give a uniform, approach towards understanding what kind of skills, what kind of expertise, and the competencies that are also required. Now, Section 82 of the Structures Act, which was initially repealed by the Systems Amendment Act of 2011, and which is now defunct. The Systems Amendment Act is now defunct. It also, it in a way gave some concessions insofar as trying to make provision for the types of competencies, expertise, and so on. Section 3 of the regulations on the appointment and conditions of employment of senior managers. This is the regulation that is affixed to the Systems Act. It does not, explicitly give the guidance as to what are these skills, the expertise, and so there's a little bit of vagueness. And as the previous speaker has alluded to, the two cases that came as a result of municipalities arguing that municipal managers or the appointments that they have made in their municipalities for municipal managers, their argument was that, look, we have appointed these two individuals on the basis of the fact that we thought they, met the requirements, and yet, to some extent, they met some of the requirements in terms of the requirement of having been a manager for a considerable, period of time. That was what, they led. The enhancement of professionalization of the local government sphere, it's what, the bill seeks to achieve. And this is primarily focused on senior managers not holding political office. Now, you would remember that in 2008, there was a case of Vuyomlokoti versus Amatole District Municipality and Mlamli Zenzile. In this case, although the case was not primarily focusing on the appointment of senior men, of the rather political interference that emanates from the appointment of that senior manager, the court ruling noted the fact that senior managers cannot hold, a political office. Next slide, Jabulile. Now, the Systems Amendment Act has inserted Section 54A, paragraph 10, the one that focuses on MEC or minister failing to respond to the appointment processes and outcomes within 14 days. And I think this has been exhausted. So I'm not going to repeat this. Please, next slide, Dabulile. Now, in terms of the contract and performance agreements, there is an introduction of Section 71B, where it states that staff members may not hold political office in a political party, whether in a permanent, temporary, or acting capacity. This particular clause is similar to Section 56A, which prohibits the municipal manager and senior managers that are accountable to municipal manager from holding political office. Now, the question is this particular clause constitutional? Given that Section 19 of the Supreme Law of the Republic gives every citizen the right to participate in politics. So is this particular section, or clause constitutional? I'm not a lawyer. I think we can leave it to lawyers to, give us guidance on this. Section 57, paragraph 6 inserts the employment contracts of the municipal managers must be signed within 1 month of his or her date of appointment. I think over time, the issue has been that you'd find municipalities appointing municipal managers, and municipal managers would, commence with their duties, and yet you find that, there is no assigned employment contract in place. So this one, it makes it clear that this is a must. It has to be done, 1 month of that particular date of appointment. Now, of particular interest again is Section 57, subsection 7, paragraph A, which gives powers to the municipal council determine if they want to appoint managers directly accountable to the municipal manager. And this Ntate Motlashuping has already explained. Now, my question in particular is why are these not made permanent, appointments? Why does this particular amendment bill give a choice to municipal councils to either choose to make contracts fixed term or permanent? Can I please have the next slide, Jabulile? The municipal manager's office remains unstable due to the nature of political environment, and this has been, alluded to by the Auditor General for as long as one can remember. And the Auditor General always makes, assertions that when you don't have municipal managers in office, the system of municipalities or system of local government through municipalities in terms of the provision of services becomes weakened. Therefore, it is important that municipal managers' offices should remain, stable. The terms of renewal of employment contract, the agreement of two parties, has been removed from the amendment bill. Have been removed from the amendment bill. But now the question then, this begs the question that why not introduce a tenure appointment for municipal managers? A municipal manager would come into a position for a period of time that would be say 1 year or overlaps 1 or 2 years, over that of the term of a municipal council. Ladies and gentlemen, I believe that I have, concluded my presentation. And once again, thank you very much for your indulgence. Thank you. Over to you, Chairperson.
Thank you very much, Dr. Madumo. I see our participants are starting to write inputs on the chats. I'll encourage many of you to start doing that. And if there are questions, I'm going to request presenters to also check questions directed to themselves. So if you have a question, please be specific. Who are you asking the question? And let's move on. I'm going to now hand over to Professor Pillay to make his contribution on the amendment bill. Thank you very much. Is Professor Pillay here? I saw him. Prof. Okay, while the team is locating him, can we have Mr. Silo Marokani from Salga to make his presentation? Thank you very much. Please show your face.
Good evening, Chairperson and all delegates and members of the Portfolio Committee. Can I ask Jabulile to present my presentation on this on the platform? Jabulile, can you please share the presentation?
Yes, I'm doing it.
Chairperson, let me upfront report that Salga has been extensively involved in the process of the development of this amendment bill. We have made submission to the Portfolio Committee in Parliament in terms of the issues that Salga felt that needs to be incorporated into the bill. We have been involved since 2016 up until 2020. Last year, that's when we made our final submission. So what I'm going to present now is the final submission that Salga made since most of the issues that we raised were incorporated to the final bill. Amongst them, Chairperson, is the three issues that Mr. Shuping has presented, that we as Salga, we made a proposal in terms of the appointment of the senior managers and MMs who are holding political office bearers. We as Salga, we made a proposal that the bill must be extended to all employees within the municipalities in order to ensure that there's no political administrative interference in the management of the municipality. So Salga's position was incorporated that now the issue of a limitation of the rights of political rights is now extended to all the municipal employees. Secondly, Chair, is the issue around concurrency. Before the bill didn't give the timeframes in terms of in an instance where the MEC doesn't respond to the concurrence for the appointment of the senior managers, it was left open, but we made a proposal that now there should be limitation, which is now included in the bill, which is 14 days after. If the MEC or the minister must not respond in terms of the waiver or giving concurrence, now the appointment will be deemed to be valid. Secondly, Chairperson, the issue that also we raised as Salga is the issue around the appointment of the fixed term period of and the permanent basis issues. That we propose that now that should be allowed to be the discretion of the municipality at the end of the term of the contract, whether the municipality has the discretion to extend or to terminate the contract. Those are some of the issues that were raised by Salga. So on overall, Salga is in support of the bill, Chairperson, and we have made our submission to the National Portfolio Committee, and the submission still stands. That's our submission in a nutshell, Chairperson.
Thank you very much. Thank you very much, colleagues from Salga. I see there are a whole lot of comments on the bill. I think we will move now swiftly to organizations represented here. Let me start with Mr. David Maimela from PolitiSpace. I know we requested you to make a 5 minutes presentation. Can you shorten it to 3 minutes? Jabu, are you getting Professor?
No, Chair, unfortunately not. I do not have his cell number and I'm trying to send the email.
Okay.
But he
Did
hasn't
we see it? Okay,
responded.
it's fine. David? Is David Mamela here? Okay. Samu, do you want to make a presentation for 3 to 5 minutes, oral submission? Leadership of the workers, do you want to make an oral submission? Imatu? Siyabonga Africa organization. Mutamai, please switch off your camera. Recopaliti me camera ya lona re Mutamai.
Siyabonga Africa is here.
Do you want to make your oral submission? You're still thinking?
Yes.
Okay, Legal Resource Center. Corruption Watch.
Good evening, Chair.
Thank you very much. Please switch on your camera. Ntate Mutamai, switch off your camera. Honorable Member Mutamai of the National Parliament of South Africa, please switch off your camera. A permanent delegate of the NCOP from Gauteng. Okay, madam, please continue.
Thank you, Chair. My name is Kavisha Pillay, and I'm the head of research and campaigns at Corruption Watch. Chair, if you'd allow me, I would like to switch off my camera whilst making this submission because my Wi-Fi is not very good. I apologize about that. Chair, I'm not sure if delegates tonight know about Corruption Watch, but I won't go into detail. Just to say that we're a civil society organization that receives whistleblower reports, of which we receive quite a large number of reports relating to corruption at a local government level. Since 2016, Chair, we've also been participating in a number and actively monitoring appointment processes to key public institutions. And we've developed criteria and processes for how transparent and merit-based appointment process should be taking place in public institutions. Chair, in terms of our initial comment on the bill, is that we do welcome some of the amendments in the provisions, and we do think that it has the potential to address some systemic corruption issues at a local government level. But what we would like to raise, Chair, that is not particularly that doesn't exist in the bill, but we think is important to recognize our principles of public participation and transparency, and how we advocate for these principles to be implemented in all appointment processes. And just to sort of refer to the Constitution, Chair, Section 1521 of the Constitution denotes that one of the objectives of local government is to encourage the involvement of communities and community organizations in matters of local governments, which to our mind includes the appointment processes of municipal managers and managers who are accountable to municipal managers. And furthermore, Section 195 of the Constitution outlines that public administration in every sphere of government should ensure transparency by providing the public with timely, accessible, and accurate information. And what we believe is that ensuring transparency and public participation in appointment processes will result in qualified and skilled candidates whose integrity is beyond reproach being appointed to key municipal positions. And we recognize that what we are about to recommend won't be outlined or won't be provided for in the legislation, but should be taken into consideration in relation to ministerial regulations and guidelines. And this is calling for the publishing or making publicly available the long list and short list of candidates, including where possible the CVs, of course, barring personal information of all applicants, conducting the interviews of candidates in an open manner, which is accessible to the public, publishing or making publicly available the minutes and resolutions of all municipal council meetings relating to appointment proceedings, as well as providing the public with a reasonable opportunity of no less than 5 working days to comment and or object to candidates who have been shortlisted for interviews. And this information received by the municipal council should be engaged with meaningfully during interviewing and deliberative processes. Now, we draw these principles and these interventions from other from parliamentary appointment processes to appoint SOE boards and so forth. And we think that some of, if these interventions are introduced, would potentially be able to ensure that qualified and skilled candidates are appointed to key positions within municipal offices. Then to go to the sort of direct comment on the bill, we at Corruption Watch welcome the expansion of political office in Section 1B of the bill, and we think that this definition, as well as the insertion of Section 71B 1A, will prohibit staff members employed by municipality from political office, and this essentially has the potential to combat political patronage within local government. Chairperson, then just moving on to Section 54A, subsection 2 of the bill. No, my apologies, 54A, my apologies, Chair. So sections 54A, subsection 8 and 9 outline steps for recourse that has been, if there's been an irregular appointment by the municipal council. And the bill stipulates that if the municipal council is accountable to the MEC for local government, who in turn is accountable to the minister. If the MEC fails in their duty to question or take action in relation to an irregular appointment, as outlined in section 54A8, the minister may intervene. However, we feel that Section 54A10 knows that if both the minister or MEC fail to respond to the outcome of that appointment of the municipal manager or acting municipal manager will be deemed to be compliant with the Act, provided that the municipality submitted all the necessary prescribed documentation. So whilst we understand this in relation to where the MEC or the minister may have dragged their feet in relation to an appointment, and this may then delay the process, we also sort of submit the following concerns: that in relation to irregular appointments, the phrasing of Section 54A subsection 10 basically renders Section 54A 8 and 9 redundant of an appropriate accountability mechanism to seek redress. And we believe that subsection 10 could be abused as a loophole for political patronage, whereby compromised candidates can be legitimately appointed should the MEC and minister not intervene in order to advance their own political agenda. But what the other challenge in this subsection, Chair, is that if the MEC fails to submit the necessary information to the minister will not have at their disposal information that is necessary to challenge those appointment processes. So in our written submission, Chair, we will make formal recommendations of how we think that this should be improved. But one of the interventions that we would recommend is that by ensuring transparency in these appointment processes, making all information publicly available, this will introduce an added level of accountability, where in the event that an MEC or the minister have failed to take action against an irregular appointment, members of the public community, activists, etc., at least have the necessary information at their disposal to challenge both the selection proceeding as well as the decision of the MEC and the minister. Chair, sections 54A subsection 11, 56, and sections 56.2b and 56.6 allow for the waiving of appointment requirements and selection criteria. And we draw concern to this because whilst we do understand that there will be circumstances where you're not going to attract a sort of sufficient pool of candidates, we do think that this potentially may be subject to abuse and will allow candidates who are not equipped or compromised to be appointed into key municipal submissions. So our submission with regards to this section is that through ministerial regulations and guidelines, the minister must clearly define what constitutes special circumstances and good cause, which will then ensure that there is a standardization in relation to the waiving of requirements for appointment. I'm almost done, Chair. We do welcome the amendments and insertions of Section 57A, which outline the appointment of dismissed staff and establishes a record of disciplinary proceedings. We particularly note the importance of having a disciplinary register to ensure that those who have been dismissed or disciplined for misconduct, fraud, or corruption are not employed in other municipalities for a prescribed period. The impact, however, we feel of such an intervention will only be realized if these registers are being made publicly available. And I think what we need to understand in the legislation is who is responsible for disseminating these registers. Will they be disseminated at a local level or will they be at a provincial level? But what we further submit in relation to this point is we believe that Section 57A, subsection 3 should be expanded to note that individuals who have been criminally convicted for financial misconduct, corruption, or fraud be permanently barred from being re-employed in any municipality. Currently, the legislation says that you cannot be employed for a period of 10 years if you've been dismissed. That is a sort of lower form of sanction, but what we do think is that if individuals have been criminally convicted for any of these, for financial misconduct, corruption, or fraud, that they then should be permanently barred from being employed in re-employed in any municipality in the country. Sorry to rush, Chair. I'm looking at the time, but for the moment, those are our initial submissions from Corruption Watch. Thank you.
Thank you very much, Ms. Play. I see President of SAMU's hand is up. You want to make contributions or a point?
Yes, we want to raise one or two matters as SAMU. If you allow us, but in fact, it's a proposal. If you allow
yes,
us,
I do allow you. You've got 3 minutes to make your oral submission.
It's too much. Chairperson, as SAMU, we take note of the consultation. However, we need to make a proposal that because we are not able to arrange an input from the entire union, we would want to submit our presentation in writing to any office that will be required to do so. We have a few issues that we would want to raise. The constitutionality in terms of what is been referred to, where staff is prohibited from participating in any political activities, the issue of collective agreements, if there are any requirements where deal with requirements where the parties need to go or SALGA need to go and consult with other bodies before consulting with in the bargaining sphere in our sector. We just want to raise certain things, but we can't do them now. We want to request that we submit them in writing after making a thorough consultation with all other structures in the provinces. We so submit, Chair.
Thank you very much, Mtate Nelson Mokhotu. I think the process is still on, and in Gauteng we are still continuing with collating submissions, written and oral submissions, and hopefully your provincial structure will also make an input towards our provincial processes in Gauteng. Socio-Economic Rights Institute, are you here? You want to make your submission? They seem to be not here. Quality Space, David Maimela?
Yes. Can you hear me?
Yes, we can hear you.
Okay, let me just give me 10 seconds to get my notes together and then I can start. Thank you.
While David is preparing himself for 10 seconds, please, Mosaic Community Development, prepare yourselves, and the Legal Resource Center. Umnotho for empowerment.
So if you can hear me now. Hi, no, I'm back. I'm ready now. Can I go ahead?
Yes, please.
So you can hear me. Okay, thanks. Really, I must take this opportunity to thank the Portfolio Committee Chair as well as the Portfolio Committee for inviting us to this important session. I think it's an important session because it, basically seeks to help us clarify a few things in relation to this bill in the first place, but also in relation to how we take forward public service in general, but also the performance of public service in order for us to actually achieve a better outcomes. So I'm gonna speak to, because I was told that I just have about 10 minutes. So I'm gonna speak to a few things that I think are crucial and things that you should look out for. And maybe I'll also make a few suggestions, but they are not exhaustive suggestions and they are not draconian, I hope. And I hope they are not reactionary. But I think that if I were to succeed in my presentation today, would be to actually provoke you to actually think and consider certain things. So the first thing I want to say is that I think that the government and the legislature, both at an executive and a legislative level, are quite correct and are on the right path to consider this question of how to strengthen and improve the professionalization of the public service from local government to provincial and national. So, and I'm careful of saying that, of putting it in that way, because my view is that the public service across the board is already professional. What is required is deepen and sharpen that professionalism and make sure that it achieves even better policy outcomes. So that's the first point I want to say. Then the second point is that I think we all agree that the debate and the bill is occasioned not only by the constitutional judgment, but I think it's also occasioned by a number of initiatives, amongst which is the idea of a single public service, and the draft framework for the professionalization of the public service, which is sitting with the National School of Governance. And it's also occasioned, of course, by this process of the bill, obviously. But most importantly, it's also occasioned by the National Development Plan and the idea of a developmental state. And I think also the other point of premise is also that the South Africa has opted for a unitary state. Now, the idea of a unitary state goes hand in hand with the idea of a single public service, because then public service has got to have the same norms and standards across the board, from local to provincial and national. Now, what are the proposals that I want to basically make is that I don't think that actually the professionalization, or rather, as I put it, the deepening of professionalization of the public service is actually an administrative or a legal question. I think it's more of a political question, which actually faces all political parties across the board, including even coalition government. Because we all know that across the world, whether you look at China or the United States or anywhere in the continent, there is a particular layer of the bureaucracy that will have to contend with the idea of political deployment. And I think that the issue that political parties are facing across the board is the question of which layer of the bureaucracy must be open for political deployment. I think it's a political question that faces political parties, and it's got to do with political will more than the administrative or the legal issue. Because even if you can enact the law and tighten the processes of selection and appointment, the idea of deployment will remain. So what is required is that there should be consensus, and it must be an institutional consensus across the board about what do you define as political deployment, what level of the bureaucracy is regarded as strategic enough to be open for political deployment. But even when you do that, in order to ensure that you've got a competent and a high-performing bureaucracy, you've got to make sure that the deployment is not a willy-nilly exercise or a willy-nilly process. You've got to make sure that there is a rigorous process of selection so that only the best and the top and the cream and the ones that are proven to have a track record can actually be deployed. Because I think the concern about the problems about political deployment, the administrative political interface, and the performance in the public service, especially at the highest level, has got to do more with performance and competence. It doesn't have, the concern is not necessarily to say deployment should not happen. Deployment should happen. You can't do without deployment, because even the most liberal state in the world, so-called liberal state in the world, the United States, has got a deployment policy and a clear framework on how a certain layer of the bureaucracy is actually deployed and how it functions. So when Trump leaves, as he left in January, then a new layer of leadership in the senior bureaucracy comes in. So then you've got to decide on the issue of the process so that you've got quality deployment. You've got to decide on the question of which layer of the bureaucracy must be open for deployment and why is that the case. So that's a debate you must have. Discuss issues of performance and so on, which are quite a fine and a detailed kind of question. But I think that we've got to think about, in conclusion, I want to say that we've got to think about training and accountability, to which extent and how do political parties actually hold accountable their employees in the bureaucracy, and how do you make sure that that happens? There's a lot of instruments and policies in place. The public service, what SMS members should look like and how they should report and perform. There's all sorts of the APP and all of that. All of those instruments are in place. So like I'm saying, my argument is that even when you have those instruments and tools, you still have to deal with the political question. To me, that is a very crucial thing. The last point, and maybe might be a controversial one, is that it doesn't matter whether you are DA, Freedom Front, IFP, or ANC. At the local government level, what we have observed, and this is also proven by research on politics inequality at local level and social mobility, is that even if you have that, the political parties have got to face, there's a particular tension that they've got to face the reality that if you have an economy that is underperforming and is exclusive, only a few people have social mobility in this type of economy, but you have a massive number of activists and cadres in the party who are your foot soldiers to make sure that you are elected, re-elected into office. Of course, there's a question of the largesse and the patronage and all of that. And so, in the end, the question of political deployment, professionalization, public policy outcomes, has got to do in the end with the question of economic development and inclusion. So it will complicate the matters for political parties because you've got to attend to the fact that people must have meaningful employment. And if you want to professionalize, you'll professionalize. On the other hand, then you narrow the space of employment and opportunity of earning an honest income. But if the economy is not growing and is not inclusive enough, then you cannot have your cake and eat it. I always have my cake and eat it. I buy it and eat it. But you cannot have your cake and eat it because really, on the one hand, the economic space is not opening for people to do all sorts of other alternative economic activities. And on the other hand, you are saying that, look, only the best and the professional must come into the fold. Thank you so much.
Thank you very much, Rema Maimela, for your insightful input. Is Socio-Economic Rights Institute here? Okay. Professor Titus Carlo, do you want to make an input? And Tate Mike Silwani, do you want to make?
Yes, thank you, Chairperson.
Okay, Prof. Carlo, over to you.
Can you hear me?
Yes, I can hear you.
Yes, and thank you, and good evening to everyone present. Let me first start by welcoming the inputs made by the panelists and also welcome the amendments to the Act in order to depoliticize and professionalize the sphere of government. I want to make the following submissions, Chairperson, in terms of the proposed amendments. The first one is on the assertion in the proposed amendment that due to the inherent vagueness of having the municipal managers being governed in terms of the Structures Act and the direct reports of the municipal managers being governed by under the Systems Act. This particular differentiation has created inherent vagueness in municipalities where municipalities had appointed managers who were incapable and ill-equipped to provide necessary leadership and supervision in order to facilitate a culture of public service and accountability. I disagree with this assertion in the sense that currently there are developed competencies and skills. I know that SALGA has developed these competencies and forwarded them to municipalities, and therefore municipal managers should possess these competencies in order for them to be appointed. So I see no reason why the differentiation in terms of the one corp of managers being governed in terms of the one act and the others being governed by the other act, bringing about this incompetence and ill-equipped skills on the part of municipal managers. And then again, in terms of the proposed amendment, there is a suggestion that a vacant post of a municipal manager should be advertised nationally to attract as wide as possible a pool of candidates. Currently, the procedure is applicable. Municipalities advertise nationally in circulating newspapers. And I'm asking myself, what about headhunting in a case where it is obvious a normal recruitment process would not yield the desired results for a particular municipality from the onset? Can municipalities be exempted from this type of a process? It is, yes, indeed proper to harmonize the processes of municipal managers together with their direct reports. It is my submission, however, that the procedures should not be the same, except that the post should be advertised nationally for both municipal managers as well as their direct reports. But remember, the direct reports of municipal managers are specialized areas where a specialized skill is required. Now, this is where the scarce skills should be sourced, like in finance as well as the head of engineering. So I had expected more exemptions to be provided to councils on the appointment of the direct reports of municipal managers. Coming to the substitution of Section 57 of the Systems Act in terms of the performance contract. Remember that performance contracts are drawn by the mayor together with the MM. The MM will enter into that particular agreement with the direct report and the mayor with the municipal managers. So measures must be provided in either the regulation or the act for consequences should the mayor or the municipal manager delay in generating his contract. It will be unfair on the part of the municipal manager or the direct report to have their employment terminated as a result of the intransigence of either the mayor or the municipal manager. So this should be included in the regulation that will form part of the employment contracts of these managers. And then my further submission is that it is a good intention of the proposed bill not to deny any member of the society their right to employment. But if you had your chance and you messed it up, why should you be afforded another opportunity? I will suggest the cooling off period be extended from 5 years to 10 years to coincide with the period in which an individual who has been convicted in a court can apply for the expungement of his or her criminal record from the database. It's like saying, on the one hand, that any individual with a criminal record, especially fraud and corruption, cannot be appointed within the municipality. But at the same time, if you have committed the criminal offense whilst you were still employed within the municipality, you are still allowed with a criminal record to be re-employed within the municipality. My concern, I hope this will be addressed by the regulations to be published by the minister, is that the movement of people who have been dismissed from the public service to local government, we know it has been rife since 2000, that those officials who have been dismissed from the public service moved to the local government sphere. And with the suspension of the Public Administration Management Act, the act that was intended to create a single public service, there has to be a provision of the recording book or the black book, as we may call it, like in the public service, where officials or people who have been dismissed due to having committed these offenses, their names are recorded. And then another submission is on the amendment of Section 67 of the Act. I think amending Section 67 of the Act takes away the nominal and the code autonomy of municipalities. If it is because of capacity, then my submission is that the provincial local government department must provide such a capacity to a municipality and not take away the right of a municipality to determine its own human resource development and management strategy. I thank you, Comrade Chairperson. These are my
Thank you. Thank you very much, Professor Titus Carlo. Professor Natasha, do you want to make an input?
Thank you, Honorable Diale. So just from my side, I fully agree with Kavisha Pillay from Corruption Watch, as well as with Professor Kalu, in terms of what they also mentioned relating to the corruption aspects and in terms of accountability, given that I think that is one of the, and especially in terms of local government, and that we find that within municipalities, and especially in Gauteng, that is one of the hot spots that we have, and that it's unacceptable that we have public servants that just pop up all over the place, you know, that they are, I want to say, serial corruptors, and then they just show up in all the different departments, and it's so I would really keep on calling for orange is the color that they should be wearing. And just on a side note, and apologies if I did miss it in one of the chats, subsection 10 could just, and it could be just from an academic point of view, but it could be legally problematic if the MEC and the minister fails to act in cases where a municipal manager is appointed in contravention with this section. The appointment will be deemed to be in compliance with the section. So it's the wording. It is inconceivable that the negligence or failure to act by both the MEC and the minister can turn an appointment in contravention of the section, so an unlawful action, into a lawful action. It may further be interpreted as being in conflict with section 54A, 3A or B, and then the subsection also refers, so the wording then they used is to senior manager, where the rest of the section refers to municipal manager. So maybe that is just something that could be considered. So thank you. I know time is short, so just brief input from my side.
Thank you very much, Prof. And nice seeing you again. Dr. Reginald Lekwabe.
Thanks very much, Chairperson. Thanks very much, Chairperson and colleagues. My presentation, just in brief, in the interest of time, basically focuses on the effect of the regulations on the municipal infrastructure space. As you know, colleagues, since 1994, that government has focused most of its budget on the rollout and delivery of new infrastructure, and that this has had an unintended consequence that smaller municipalities have inherited new infrastructure and unfortunately are not able to operate and maintain. And this being the precursor of poor infrastructure, asset management, collapsing infrastructure, and the main trigger for community service delivery protests, that the primary cause of service delivery protests across the country remain the delivery of basic municipal services such as water, electricity, sanitation, the poor state of roads, access to housing, etc. So empirical studies within the domain of the local government sector indicates that the sector is beset by a series of infrastructure challenges, the migration of older, experienced built environment professionals out of the sector. Now, the studies I'm referring to are the Municipal Demarcation Board capacity assessments since 2011, the latest one being the 2018 capacity assessments, as well as the numbers and needs I think it's within the civil engineering profession. But overall, the findings, if you consider also the Department of Water Affairs reports, but also the stemming from the State of Local Government report of 2009, that the findings are consistent, that there is a migration of experienced built environment professionals out of the sector. They have been replaced by younger, relatively inexperienced, averagely between 3 to 5 years minimum average experience. The majority, those who operate within the statutory professional bodies, are not registered. There's high vacancy rates within infrastructure departments of municipalities, increased workloads and falling staffing levels, that municipal technical departments are unable to spend their MIG allocations, frequent rollovers, frequent audit findings on poor infrastructure asset management, service delivery, sewage spills, water quality issues, refuse non-removal. That averagely, that there's only 41% of technical services managers with a degree, that the 50% of municipalities have had their infrastructure directors in place for less than 2 years. And the worst affected are the category B3 and B4 rural local municipalities, more specifically, the worst being in Free State, Northwest, Eastern Cape, and Limpopo. That Gauteng is not doing so badly, but however, these are the overall findings. And that generally, that the inadequate operations and maintenance, it poses potential for disasters, compromises public health, environmental integrity, and the financial sustainability of municipalities. On slide 6, basically, colleagues, just to indicate to you that overall, according to the demarcation board, that if you look at the qualification levels of municipal managers and compare them with CFOs and technical directors, you'll see that overall, municipal managers are highly experienced and qualified, followed by CFOs. And the reason why this is the case is because of the extended focus by Treasury with the minimum competency regulations on chief financial officers, such that what one is saying is that if we are to stem the key issues of causing service delivery protests and loss of institutional management capacity, especially with regards to key service delivery roles, we have to zero in on the qualifications and experience of municipal infrastructure managers, technical services managers. As you will see a figure at the bottom there, colleagues, you'll see that some provinces are worse affected than others. But the point that one is trying to say is that empirical studies within of the sector indicate clearly that the failing institutional and management capacity within the technical services, within the ability of municipalities to deliver services, is what lies at the root of failing infrastructure. Next slide. So in terms of this slide, colleagues, in terms of the statutory amendments on section 56(1)(a), or rather section 56(b), that says that a person appointed in terms of section 56(1)(a) must have the requisite skills, expertise, competencies, and qualifications as prescribed. These refer to, because these are regulated professions, colleagues. For example, with the civil and electrical engineers employed by municipalities, to a less extent, your quantity surveyors, but your building inspectors that are regulated by the SACP-CMP, your construction project managers and your construction managers. To a less extent with town and regional planning, this profession is doing quite well in the sector, but as compared to the other built environment professions, for example, in some entities, you would employ your hydrologists. These are regulated professions. So if the regulations, the Systems Act, the amendments indicate that we need to appoint a person with the skills, expertise, and competencies. They refer to the statutory provision of the professional body that regulates minimum academic qualification, experience, and professional registration. And in implementing the amendment to the Systems Act, there will be a significant cohort of infrastructure officials who are currently not compliant, but who occupy these roles and who some are experienced to fulfill those roles, but unfortunately will not be compliant because this being a regulated profession, they may not have had the minimum academic qualifications or the professional registration, or are not registrable because you may find a teacher fulfilling engineering work. You may find candidates. In some cases, you find other professionals from other professions fulfilling key infrastructure-related work in the water, sanitation, roads, and these are regulated spaces, colleagues, and hence the challenge for GCOG, for CoGTA and the provincial CoGTAs is to make sure that we are able to. There needs to be some sort of regime that speaks to minimum competency regulations. That the amendments cannot simply be applicable as in day one. That we need to allow opportunities for those officials who are currently employed in the space, but who do not meet the minimum criteria for compliance with the Systems Act amendments. That also further, what tended to happen in the past was, for example, CoGTA at some point instituted regulations on the appointment of and the conditions of employment of senior manager in the government gazette. I think this was gazetted on the 7th of March 2013 in terms of section 72 of the old local government Municipal Systems Act. Now, if you look at what was contained in these regulations, some of the regulations basically watered down what is the statutory requirements. The requirements for a civil engineer in the private sector shouldn't be watered down simply because this person is employed in the local government sector. And this is one way where we are able to ensure that technical professionalization, especially within those regulated professions, persist. And next slide. That in some cases, for example, Section 56 says that, all right, this matter was discussed. Section 56 managers reporting to the municipal manager. It is a good thing that that municipalities will be given the option to go to choose whether to hire on a full-time or on a contract basis. But fixed-term contracts, they tend to foster short-termism. And there has been a school of thought that says that fixed-term contracts make senior managers susceptible to undue political influence because they need to garner the goodwill of council so that the contract is renewed for the next 5 years.
As we conclude, Dr. Lekwabe?
That although permanence is good for stability, there is a potential. We need to strike a balance between stability in the administration and permanent appointments. Colleagues, I think I will stop here. But just in closure, that there needs to be minimum competency regulations that are put in place for non-compliant officials, infrastructure officials, in similar vein in terms of what was done by National Treasury with regards to the minimum regulations for the CFOs, that a specific period was given for municipalities to be able to comply with certain requirements. And that there needs to be capacity within CoGTA for compliance inspection and enforcement. Meaning the focus should be more on implementation. The that oversight, for example, on the implementation of the fraud register, the list of dismissed staff, the central record of disciplinary proceedings, that these need to, the clear areas of accountability need to be established. Thank you very much, Chairperson and colleagues. Thank you.
Thank you very much, Dr. Lukwabe. I think as a portfolio committee, will also take it further with yourself on the presentation that you just made. And I think we all agree infrastructure development is one of competencies that municipalities struggle with. I'm just going to check from the audience on MS Teams who wants to ask a question, and I've not noted on my list. Khoto Maja, do you still want to speak?
Chairperson?
Okay.
Going to unmute.
Okay. Ntate Silwane ere go bue ba banyane pele, and then you'll come and close it. I see Khoto Maja wants to speak. I see Dumisani, Magagula, Sidwell, Mofokeng. I don't know what that who is live.cid. It looks like a student number. And you've been raising your hand for quite some time. Maybe let's start with you before we go to Khoto. You have not identified yourself properly, so I can just see live.cid 59. There's a quote there. Okay, it means he or she doesn't know how he is. Okay, your mic is on. Speak.
Hello, I'm Katlego Motlagodisa.
Okay,
I just want to make the input on the amendment, especially on the issue of the period for acting, whereby the act says the municipal council may. It does not give the municipal council the mandate or compulsory that they must write to MEC requesting that the person who's being active for 3 months can be extended again for another 3 months. And then when you go to the act again on the issue of the waiver, there's little confusion there, especially in municipal council, to interpret if they have advertised the post nationally and they have attracted some candidates, and then they only find out that all these candidates don't meet requirements, but because of political influence they have a certain person that they want who don't have requirements, and then they apply for waiver to municipal to minister to reduce the requirements. With my understanding is that you only apply for a waiver so that you can issue another advert that is a requirement waived according to what the municipal council has asked the minister to do. So my appeal is that the act should be able to be clear on the issue. How do you apply for waiver? And after the waiver is being approved, the particular post should again be re-advertised with that requirements that are being waived. Other than the current circumstances that you find, they appoint somebody who is qualified for technical services in the position of municipal manager or other way around. So those are my inputs in terms of submissions on the Amendment Act. Thank you.
Thank you very much, Katlego. Khoto Maja.
Okay, thank you very much, Chairperson. I'll be very brief. Firstly, I think the amendments are well-spirited in a sense that they are meant to transform the way in which local government operates. However, in that attempt, from the presentation, for example, by the likes of David Mamela, you pick up that maybe in the attempt to professionalize the local government space, there are certain insertions or amendment that I may not necessarily go down well. In my view, the limitation of yes, in 2011, and this was inserted for municipal managers and those who directly report to municipal managers. But also this was a limited definition of what political office is. So what happens with this bill is that it doesn't only expand this limitation to staff members, but it also expands the definition of political office to also include those who are elected or appointed in any decision-making position. So this means effectively, Chairperson, that a very huge majority of public servants will be affected, because in fact almost all positions of leadership in a political party are affected by this amendment, because a political party is structured in such a way that its structures are decision-making in nature, and a very few of those are coordinated, and those coordinating structures are usually temporary types of structures. So this means that a majority of those people who choose to exercise their freedom of association and to exercise their affiliation politically are actually barred from not only now being municipal managers or those reporting to them, but also being staff members generally. I think this was meant well, but it's not necessarily a welcome intervention. And I make an argument that, in fact, the Principal Act as is, as well as the Constitution, in as far as local government is concerned, brings or makes provision for what I call sufficient safeguards. Because what I believe these were introduced to do was to arrest some of the problems that previous presenters have already spoken to, including lapses in good governance, financial mismanagement, and other findings, for example, by the Auditor General. But I believe that the Principal Act and the Constitution does provide a sufficient safeguards, and it's a matter of both the MEC and the Minister being very strong monitoring and holding the municipalities or the municipal councils accountable, instead of limiting even, I may argue, the constitutional rights of the staff members. And another thing which, Chairperson, I did not hear in this, and maybe it was resolved elsewhere through a case law.
As you conclude.
Yes, Chairperson, this is my last point. It's with regards to section 56B, which says that a person appointed in terms of paragraph A, whatever, must at least have the skills, expertise, competencies, and qualifications as prescribed. The original text is in 2000 actually taking into account the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. So now, what the amendment does, in fact, from 2011 already, this part of that text no longer appears, and maybe in further interactions and consultations, it can be clarified as to what was the rationale of removing this qualification, that we should take account of, transformation objectives, basically, when we make these amendments, because that has been removed entirely. There are a few other issues, Chairperson, but I will sneak them into the chat room where permissible. Thank you very much for the opportunity.
Thank you very much. Ntate Max Loni.
Thank you very much, Chairperson. Our participation as follows: that of the PSC is to promote the constitutional values and principles enshrined throughout the Constitution. However, it is restricted to the public service, and we also evaluate the performance of the public service with regard to the constitutional values and principles. So Parliament decided that we should extend the mandate of the PSC, especially for the evaluation and monitoring of performance, to local government and state-owned enterprises. That calls upon amendment of the constitution of the PSC or the act of the PSC to ensure that they extend it to the mandate to local government and state-owned enterprises. With respect to the bill, the Municipal Systems Amendment Bill, the PSC welcomes it and support the bill because it will ensure that local government public administration is also governed by the democratic values and principles which are enshrined in the Constitution, especially a high standard of professional ethics that must be promoted, and that good human resource management practices and career development practices to maximize human potential must be cultivated. Secondly, we support the bill because it will go a long way in professionalizing the public service, especially when it comes to appointments at senior management level, to ensure that right people are appointed for the right jobs. And then thirdly, we support the bill because it will go a long way in improving political and administrative interface, especially ensuring that officials of municipalities are not involved in active politics of parties. That is what we will support. As to, unfortunately, we have not been called upon to give a written presentation, but if you need, all these small remarks can be given to you in the next day also by our office. I thank you.
Thank you very much, Rasilwani. We still have until the 9th of May. And if PSC wants to make a written submission on the amendment bill, you can still do so and send it to our office. Thank you very much, Raleboga. I see Ntate Dumisani Magagula.
Thank you, Chair. Kedibone. I think that the latter part of what you just submitted is what we wanted to raise. And we are worried by the format in which you are responding. PSC asked the same thing that we asked. Where do we send our submission? And we were directed to some participatory program that's still running in Gauteng. But I think what you need to do is to treat us the same way, that we should submit to a specific office after we have done our work. And we take that what we need to submit as an equal party in the process, and more especially as a major stakeholder, as representing labor in this department of CoGTA. So will you kindly share that, even if you have someone sending it to us, where do we send our submissions? Thank you.
Thank you very much, Ntate Dumisani Magagula. Jabu and Ntombi will keep in contact with yourself. If you can just leave your contact details on our chat room if they don't have, so that they consult and send you where you must send the bill. And I think advertisement of this platform had all the details. And my apologies if communication was not clear to yourself as a union. Thank you very much.
Okay.
Thank you. I've seen local government practitioners on the platform, and I've seen some of you have been interacting with some of our panelists in the chat room. I don't know if you want to make contributions before members, honorable members, make their inputs in moving forward. We are still also to have public participation processes across all the municipalities. We have regionalized them. I think we'll be having 4 public hearings in all 4 regions of Gauteng. This is a Gauteng process. I know we are very influential as Gauteng, and people tend to come to our processes believing it's a national program. This is a Gauteng program, And I know our colleagues at the National Assembly are also to embark on a similar process and in other provinces. So, but we will submit your submissions on your behalf if you send them to us as the Gauteng Provincial Legislature. I've seen local government practitioners and former local government practitioners. I don't know if you want to make inputs before we open up the session for honorable members. I've seen Blessing Manali making an input on chat room. Anyone?
Chairperson.
Sidwell Mufukeng.
Yeah, Chairperson, I'm in a different, thank you very much. I'm in a different capacity today, former local government practitioner also.
Okay.
And I'm part of the group. Let me just quickly make my submission. Safe to say that one welcomes the amendments, and we have been also working with Datemotla Shuping with the input, so this process is not new to us. So I just want to raise, take off from where Dr. Lekwabe ended. I think that's where we want to come today in a capacity from a professional body side, that what the bill needs to do, and this is going to be our further submissions, that the objective behind the amendments must be clear or clearly spelled out as to avoid any confusion in terms of what we are seeking to achieve. If we are seeking to achieve to depoliticize, we must then precisely spell out the how of the depoliticization and ensure that we bring those amendments without necessarily trumping the rights, the constitutional rights of employees, as that matter has been adequately canvassed on this platform. If we are to professionalize, we also have to spell out exactly the understanding of professionalization, align it to the framework that Comrade Mike has spoken to and other colleagues with the public service process, where we need to talk about the process of professionalization being a system that we need to inculcate of accountable professional public service, which in this instance must include local government. Look at the institutional arrangements in terms of how local government is structured and the capacity assessment of each structure of local government and the requisite skills that must support such institutional arrangements. So when we talk professionalization in that context, so that we don't use the terms interchangeably. When we talk to the question of professions, particularly at senior management level, and the points that Dr. Lekwabe clearly articulated and canvassed are the points that we strongly support, that we have to make sure that even the professions or descriptions of professions or classifications of professions in local government in accordance with the framework, organizing framework for occupations that governs the country should then also accord the same for local government, so that in terms of the pipeline of skills that we need to develop, right from the elementary skills up to the professional level, we are clear as to what we want to achieve if we are to achieve a professionalization. Of course, the professions themselves, we need to read the regulations on the competency recommendations for appointment of senior managers. It's a process that we need to review concomitant to this process in terms of definitions of professions and the minimum competence or the minimum requisite competencies required to be appointed across the various professions in local government. And that area is an area that is still lacking, and I'm hoping that Mr. Mutla Shuping will pick up that process so that we can finalize it before the bill is enacted. The other issues, Chairperson, because they are lengthy,
as you close.
Yes, I'm not going to talk to them. It's part of our submissions that one will submit to you just to indicate the alignment in terms of what we want to input in this process. Thank you, Chairperson and colleagues on the platform.
Thank you very much, Date Mufukeng. I think the team, Jabu, please make sure that the presentations are sent to participants that are requesting them, that have written their emails on our chat group. I see, honorable members, you'll pardon me, I want to start first with stakeholders and then come to you. I see Ms. Cynthia Ramulifu. I know you've been with City of Joburg and City of Tshwane. Please make your input. I think you are an HR practitioner, isn't it? Or corporate and chat.
Thank you, Honorable Chairperson, and good evening to the honorable members and the stakeholders. Mine I will also be submitting because I've previously submitted with regards to the omission or the definition of a secondment. In various municipalities, as a former practitioner in the local government, especially Section 56 direct reports, you find challenges in movements or rotation or moving of personnel staff from positions that they've been appointed and to render certain services. And in the absence of not having an inclusion on the senior management appointment on the secondment, it's also something that the CoGTA was previously given to look at and investigate further, so that it can be find expression within the legislative amendment. That is one. Two is the aspect of the appointments of the chief of police read in line with the SAPS Act. I'm not too sure how they are finalizing such appointment, because in two municipalities, especially with City of Tshwane, it was an issue of two dually reporting. And however, there was a proposal that CoGTA will look at this in terms of how they can iron the arrangements so that the MEC of CoGTA can also have oversight and control in terms of either aligning it to the community safety and so on. So with those, I just needed to just highlight as I will be submitting another formal submission. Thank you, Honorable Chairperson.
Thank you very much, Cynthia, for those valuable inputs. I've seen on the platform mayors and councillors, and municipal managers. Is there anyone who wants to make an input before I go to honorable members? Dololo, input. I've seen Member Ngube and Member Mutamai's hands are up. Let's start with you, Member Ngube.
Thanks, Comrade Chairperson. Thanks for from the presenters what they've done to us. The first one, Honorable Chairperson, maybe there might be people that are participating from social media and wherever, but that do not have maybe the email address to send their inputs. So if you can help them by pronouncing here in terms of where to send. The second one, I think I'm a little bit covered by the last but one speaker in terms of the clarity of what is meant by professionalizing or depoliticize, because it may happen that I am a treasurer, an office bearer, we say that. I am an office bearer of a political organization. It doesn't mean that all the politicians are not learned. And then the bill suggests that you must not be practicing to be a political leader. However, when I apply, I'm not sure whether I'm gonna be appointed or what. But if it is clear that if appointed, then I relinquish that position, maybe it can help because we're not, so that it doesn't bar people that have skills, But because they are leaders and they are in the top 6 or top 5, then we are then bad. But once you are appointed, I go to an interview, I declare, yes, I'm currently a chairperson, a deputy chairperson, a deputy president, and whatever. However, if appointed, then I will relinquish. I think it may cover something. Thank you.
Thank you very much, Member Ncube. Ntate Motsamai, you want to make an input?
Yes, thank you, Chairperson. Chairperson, number problem one is about municipality manager and the CFO, especially in the place like Mfuleni, where I came from, where the municipality is in ICU and our executive mayor is there. And when you want to see even the executive mayor, he can't even pick up your phone or answer even your right to them. The problem is one on that municipality. You ask yourself, the MM, you want to meet with him because of the problem that is taking place. More Mfuleni. Then you ask yourself what the qualifications, because they cannot even allow you as a parliamentarian, even the executive mayor, you call him, you write him SMS, you do everything. But now he is here. Mwerani is here. I keep it all. Qualifications about you.
Okay, ra lebogang Ntate Motsamai. Re Mwerani re kopa gore le re thulaganyo ya gore le kopane le Re Motsamai. Gongwe o le contacta a berekisa your personal assistance, ke kopa gore le dire gore le be le di-cell number tsa Ntate Motsamai gonne ke representative ya rona ko NCOP re le Gauteng. So re a go kopa tswetswe Re Mwerani. Are you still here, Ntate Mwerani? Ntate Motsamai, re tla dira gore le be le di-cell number tsa mayor gore le kgone go bua le ene directly ge le mo tlhoka. Ke a leboga Ntate. Are there any persons who wants to make inputs?
Yes, I do, Chair.
Okay. David Maimela?
As a guest, I hope I'm still allowed.
Yeah, 1 hour 30 seconds. 1 minute 30 seconds, sorry.
No. I'm even going to be probably shorter than that. No, I just wanted to say that the first thing is that let's just make sure that the process is aligned with the national process of the DPSA and the whole idea of a single national public service. Then the second point is that I really beg to differ. And I've not yet been convinced or been rebutted in my mini thesis about this. I don't think that there's any state in the world that can achieve the depoliticization of the bureaucracy of the state. It's impossible to do that because the state itself is a product of political processes and politics. So the bureaucracy is part of the state. And so, it's difficult to can do that. So what I always argue when I present or discuss this matter is that the concepts that are used are not appropriate. You can't depoliticize the state. You can't achieve that. Not possible. But what you can do is that you can deepen, refine, redefine political.
Maimela, please hold on.
I've made my point.
Hold on.
I think I've made my point, Chair. But
okay.
in summary, I'm just saying that.
No, hold on. I just want to call Khositsile Matlakane. Re tlo bona batho ka mapona. Please switch off your video. We don't want to be exposed to things of people above the age of 18. Just hide it, cover your camera with a cloth. David Maimela in 30 seconds.
And it's exactly the wrong time for this type of thing. So, Chair, what I wanted to say really is that let's find the correct nomenclature and concept of what we're trying to do. I think the outcome is clear as to what you're trying to do. And my view is that you're trying to deepen. We're trying to deepen the professionalization of public service. We're trying to make sure that the processes of selecting the best amongst us actually works. But the idea of depoliticizing the state or the bureaucracy is wrong and it's not going to happen. It's impossible to achieve. That's the point.
Okay, thank you very much, David. I think it's a further discussion to be taken, and we've noted much interest on the subject matter, and perhaps maybe if time and space allow, we'll have follow-up discussions as Gauteng, especially because we need to really perfect the local government system within our boundaries. I'm now going to hand over to our panelists to make their parting shots. I'll start with you, Dr. Sam Koma. I see there's been discussions on the chat group, and I hope that in exchange of emails, you'll take it further. But also just to say that as CoGTA Portfolio Committee, we value your participation in all our processes, but also as experts, activists, practitioners in the space of local government, we will value you more if you come work closely with us as we do our proactive oversight and ensuring accountability within CoGTA, as well as in municipalities across Gauteng. So over to you, Ntate Koma, and then we'll be followed by Dr. Madumo, as well as Ntate Marukan.
Oh, thank you, Chair. Just also to indicate that I've been replying to some of the input and questions that are raised on the platform, quite interesting. But I just wanted to respond to the question for clarity, which was raised by Katlego during the plenary regarding the waiver around the re-advertisement of the post of the municipal manager. Just to indicate that Section 54A, subsection 2, should be read together with subsection 5, because subsection 4A, subsection 2 reads as follows: a person appointed as municipal manager in terms of subsection 1 must at least have the skills, expertise, competencies, and qualifications as prescribed. Then when you move to subsection 5, it says the municipal council must re-advertise the post if there is no suitable candidate who complies with the prescribed requirements. So in a nutshell, when you re-advertise the post as the municipality, the requirements as prescribed in the Act plus the ministerial regulation remain the same. You can't amend, you can't tweak, you can't change. So when you re-advertise, the very same requirements required of a suitable candidate for the position of a municipal manager remains the same. You're still looking for a holder of a bachelor's degree, either in social science, public administration, or law. You're still looking for that 5-year senior management experience, plus the other competencies that are provided in the regulation. I just wanted to provide that particular clarity, but also to agree with the view raised by David Maimela. Of course, I read your opinion piece published in the Eyewitness News Online. I do agree. In fact, we're not talking about depoliticization of the public service, because in practical terms, we cannot divorce politics from administration, but we're saying as part of the experience that we have had for the last 15 years, especially in the sphere of local government, is it not opportune time to move towards some kind of professionalizing the administrative arm of a municipality? And that is the reason we have these stipulations in the Act and also the regulations that have been provided by the minister in terms of the requirements that municipal officials need to possess as part of being considered for appointment at the senior level in a municipality. But I do agree with you, we cannot have the separation of politics and administration in the context of South Africa, in the context of the continent, and also elsewhere in the world. Thank you.
Thank you very much, Ntate Dr. Koma. Dr. Madumo.
Thank you very much, Chairperson. Well, my part in short, I want to reflect a little bit on, the political deployment issue that has been raised by David Maimela. And of course, I concur with, the response that Dr. Koma has, adequately given. However, my take is that we need to, be quite deliberate in our actions, in our approach, insofar as this political deployment is concerned. And I think it's high time we start, discussing the very same issue of political deployment of senior officials within either municipalities or provincial government or even the national government. And also the other issue that I want to reflect on, it's the issue on staff members prohibited from holding political office. This, I believe, is going to be a contentious issue, and it may even question the constitutionality of this particular amendment bill. I think that is my submission. Thank you very much for the opportunity, Chairperson.
Ra leboga Dr. Koma le Dr. Madumo ra re le ka moso. Ntate Marokani? Is he still here?
Yes, Chairperson. As indicated that we have made a submission and we support the bill as it stands.
Okay. I thought you wanted to make your parting shots. Thank you very much, Re Marokani. I'm now going to, unless if there's someone who feels they need to make an input, in 30 seconds. If there's none, I'm going to hand over to Honorable Member Greg Schneeman to do the vote of thanks, and I would like to thank all of you for being good audiences, and I hope we have now started building a relationship ourselves with yourselves as key stakeholders within the Gauteng communities, and I hope that we will engage each other further on different aspects of local government as we continue to do our oversight and ensuring accountability of the executive in the Gauteng provincial legislature. And hopefully some of you will continue with some of the arguments you raised here in shaping our policies and our legislation moving further. Thank you very much for your participation. Honorable Schneeman, over to you.
No, thank you very much, Chairperson. And just before I do the actual vote of thanks, maybe just to say as well that I think the participation in tonight's session has delivered some very rich discussion. And I think the numbers of people that have joined both on this particular platform and on the other platforms as well indicates the level of interest and the desire to make a contribution to the path that we need to be traveling, and particularly in terms of this piece of legislation. And I'm sure that we will, obviously as a committee as well, have to take all of these points into consideration when we finalize our own position in Gauteng. But I think then just to say thank you very much to everybody that has joined this particular session. Thank you very much for the contributions that you've made, which in various ways, I'm sure, will shape the final product of this bill, and certainly will help to shape the position of Gauteng that we eventually adopt and is taken forward back to the National Council of Provinces. So thank you to everybody. We look forward to receiving the various written submissions, which some of you have indicated you'll be submitting, and look forward as well, I guess, Chair, as well, to the rest of the discussions that will be taking place as we move throughout the province. But once again, I would want to say that tonight's discussions have been extremely rich and have been quite eye-opening in some respects. And there's been a couple of areas that have generally got comment from most of the speakers. So once again, thank you very much. Would also like to express our sincere thanks to Mail and Guardian for giving us a platform on their platform and for broadcasting this session, and also thank the committee support team for all the work that they've done in ensuring that this discussion and these hearings have been so widely advertised, and also thank everybody else who has played a role in helping make tonight's discussions the success that they've been. And we look forward to interacting with some of you in the future sessions that are going to be taking place around the province. But as I say, thank you very much. We appreciate the effort and the work that you've gone to in making your contributions and your written submissions as well. So on that note, Chairperson, let me hand back to you. Thanks very much.
Thank you very much, Honorable Member Schneemann. I think you have done the closing. We are done. And thank you, everybody. Thanks to our panelists. Good evening to all of you. Sintanda nonke makhaya.
Thanks, Chairperson.
Thank you, Chair.
Thank you and good night.
Good night. Thank you.
Thank you. Thank you.
Thank you. Good night.
Thank you.
Long live the chair. Long live.
Good night.